In 2019, a woman named Margaret Holloway received a certified letter from a law firm in Connecticut she had never heard of. She was 54 years old. The letter informed her that she had been named as a beneficiary in her grandmother's estate. Her grandmother had died in 2007, 12 years earlier. Margaret Holloway grew up in a family that valued silence over confrontation. Her grandmother, Dorothy Crane, was the matriarch of a modest New England family. Dorothy owned a small textile business that had been in operation since the 1960s. It wasn't lucrative, but it was stable. She lived in the same house in Bridgeport, Connecticut, for 43 years. The house was a two-story colonial with white siding and green shutters. It sat on a corner lot in a neighborhood that had seen better days but remained respectable. Dorothy had bought it in 1964 with her husband, Robert Crane, who worked as an accountant for a manufacturing company. Robert died in 1989. Dorothy continued living there alone. She kept the business running until 2001, when she sold it to a competitor for a modest sum. The sale gave her enough to live comfortably, but not extravagantly. She was careful with money. She clipped coupons. She drove the same car for 15 years. Dorothy had 2 children. The first was Margaret's mother, Elizabeth. Elizabeth married young, had Margaret in 1965, and maintained what most would describe as a respectful but distant relationship with her own mother. Elizabeth lived in Rhode Island, about an hour from Bridgeport. She visited Dorothy on holidays, sometimes on birthdays. The visits were polite. They did not argue, but they did not confide in each other either. Elizabeth worked as a school administrator. She raised Margaret mostly on her own after her husband left when Margaret was 7. Elizabeth died in 2003 from complications related to diabetes. She was 61 years old. The second child was Margaret's uncle, Richard Crane. Richard never married. He worked in insurance for most of his adult life. He lived in Hartford, about an hour from Dorothy's home in Bridgeport. He visited his mother regularly, at least once a week in her later years. He handled her finances when she began to struggle with bills and paperwork. He was named executor of her estate. Margaret had seen her grandmother perhaps a dozen times in her adult life. The relationship was cordial, but not warm. There were no deep conversations, no shared secrets. Margaret would visit for Christmas, occasionally, or stop by if she was passing through Connecticut. Dorothy would offer tea and cookies. They would talk about the weather, or Margaret's children, or nothing particularly important. When Dorothy died in November 2007, Margaret attended the funeral. It was held at a small chapel in Bridgeport on a cold, gray afternoon. There were fewer than 20 people in attendance. Richard organized everything. He stood at the front, greeting mourners, accepting condolences. He thanked Margaret for coming. He mentioned that Dorothy's affairs were being handled. Margaret assumed that meant probate was underway. She never heard anything further. No one contacted her about the estate. No lawyer called. No documents arrived. Margaret assumed her grandmother had left everything to Richard, which seemed reasonable given how much time he had spent caring for her. Margaret knew that Richard had been Dorothy's primary support in her final years. It made sense that he would inherit the house, the savings, whatever else there was. Margaret moved on. She had her own life, a job as a human resources manager in Providence, Rhode Island, a mortgage on a small house in a quiet neighborhood, 2 children, both in college by 2007, a handful of close friends, a routine that kept her busy. The passing of her grandmother became a memory, then a footnote. 12 years passed. The letter that arrived in April 2019 was brief. It was from a law firm called Pemberton & Associates, based in New Haven. The letterhead was simple. Black text on white paper. No elaborate. Logo. The letter stated that Margaret had been named in the last will and testament of Dorothy Crane. who had passed away on November 14th, 2007. The firm was now handling the estate and requested that Margaret contact them to discuss her inheritance. Margaret read the letter 3 times. She stood in her kitchen, still holding the envelope. The letter did not make sense. She had not been contacted in 2007. She had not been contacted in 2008 or 2009 or any year since. She had assumed the estate had been closed over a decade ago. She checked the postmark. It was dated 3 days earlier. She checked the law firm's name online. Pemberton and Associates was a legitimate probate firm in New Haven. The address matched. She called the number on the letterhead. A receptionist answered. Margaret asked to speak with Stephen Pemberton. She was put on hold for 2 minutes. When Pemberton came on the line, his voice was calm and professional. He asked if she had received a letter regarding Dorothy Crane's estate. Margaret said she had. She asked why she was being contacted now, 12 years after her grandmother's death. Pemberton explained that the estate had only recently been reopened. He said that Dorothy's will had been located in a safe deposit box that had gone unaccounted for during the original probate process. The box had been discovered during an audit by the bank in late 2018, more than 11 years after Dorothy's death. Margaret asked why no one had informed her in 2007. Pemberton said he did not have the full record of what had occurred during the initial probate. He had only been retained in 2019, after the will was found. He said that it appeared the will had never been submitted to the probate court. He suggested that Margaret come to his office to review the documents. Margaret asked if she needed to bring anything. Pemberton said no. He just needed her to verify her identity and review the terms of the will. She made an appointment for the following week. Pemberton's office was located in a converted historic building in downtown New Haven. The waiting area was quiet. There were leather chairs and a few outdated magazines on a side table. Margaret arrived 10 minutes early. She had taken the morning off work. She had not told anyone where she was going. She was not sure what to expect. Pemberton met her in the lobby. He was in his mid-50s, with graying hair and wire-rimmed glasses. He led her to a small conference room and offered her coffee. She declined. He placed a folder on the table between them. Inside was a copy of Dorothy Crane's will. Dorothy Crane's will was dated March 12, 2005. It was a standard typewritten document, notarized and witnessed by 2 individuals whose names Margaret did not recognize. The will was 4 pages long. The language was formal but clear. It divided Dorothy's estate into 3 parts. The first asset was the house in Bridgeport. The will instructed that the house be sold, and the proceeds divided equally between Richard Crane and Margaret Holloway. The second asset was a savings account held at Webster Bank. At the time the will was written, the account held approximately $87,000. The will stated that this amount was to be split equally between Richard and Margaret. The third asset was a life insurance policy worth $150,000. The policy had been taken out in 1992, shortly after Robert Crane's death. Dorothy had maintained it for 15 years. Half of the payout was designated for Richard. The other half was designated for Margaret. Pemberton walked Margaret through each section. He explained that the house had been appraised at approximately $220,000 in 2005. If it sold for that amount, Margaret's share would be $110,000. Her share of the savings account would be $43,500. Her share of the life insurance would be $75,000. In total, according to the will, Margaret was entitled to approximately $228,500. She had received nothing. Margaret sat in silence for a long time. She asked Pemberton, what had happened. Stephen Pemberton explained that when Dorothy died in November 2007, her estate had gone through probate in Connecticut. Richard Crane, as executor, had filed the necessary paperwork with the probate court in Bridgeport. According to the court records, Richard had submitted an affidavit stating that Dorothy had died intestate. Intestate means without a will. When someone dies without a will, the estate is distributed according to state law. In Connecticut, if the deceased has children and no spouse, the estate is divided equally among the children. Richard was Dorothy's only surviving child at the time of her death. Elizabeth, Margaret's mother, had died in 2003. Under intestate succession, Richard inherited everything. The house was sold in June 2008 for $210,000. The proceeds went to Richard. The savings account, which had grown to $91,000 by the time of Dorothy's death, was transferred to Richard in early 2008. The life insurance policy was paid out to Richard as the sole heir in December 2007. Richard had received the entire estate, approximately $451,000 in total. Margaret asked Pemberton why Richard would have filed an affidavit claiming there was no will if a will existed. Pemberton said he could not speculate. He said that Richard had either been unaware of the will or had chosen not to disclose it. Margaret asked if that was legal. Pemberton said it was not. Failing to disclose a will is a breach of fiduciary duty. An executor is legally required to conduct a thorough search for any testamentary documents before filing an affidavit of intent. In some cases, failing to do so could be considered fraud. Margaret asked what her options were. Pemberton said she could file a claim against Richard for the amount she was owed under the will. Connecticut law allows for estates to be reopened if a will is discovered after probate has been completed. Beneficiaries who were wrongfully excluded have the right to recover their inheritance, but recovery depends on whether the executor still has the assets or the ability to repay them. Margaret asked if Richard still had the money. Pemberton said he had attempted to contact Richard multiple times. He had sent letters to Richard's last known address. He had called the phone number on file. He had sent emails to an address listed in the probate records. Richard had not responded to any of them. Pemberton said it was possible that Richard no longer had the funds. It had been 12 years. The money could have been spent. It could have been invested and lost. It could be tied up in assets that would be difficult to liquidate. Or Richard could simply be unwilling to cooperate. Margaret asked what that meant for her. Pemberton said it meant she would likely need to proceed with litigation. The safe deposit box had been rented by Dorothy in 1998, 3 years after her husband Robert died. It was located at a branch of Webster Bank in Bridgeport, the same bank where she held her savings account. According to bank records, Dorothy had paid the annual rental fee every year until her death. The payments were automatic, deducted from her checking account each September. After she died, the fees went unpaid. Banks have specific procedures for handling unpaid safe deposit boxers. Typically, after a certain period of non-payment, the bank will attempt to contact the renter or their estate. If no response is received, the contents are inventoried and turned over to the state as unclaimed property in Connecticut. That process usually takes 3 to 5 years. In Dorothy's case, the box was flagged for review in 2012, 5 years after her death. A notice was sent to the address on file, which was Dorothy's house in Bridgeport. The house had been sold in 2008. The notice was returned as undeliverable. The bank attempted to contact the executor of Dorothy's estate, Richard Crane. A letter was sent to the address Richard had provided during probate. There is no record of whether Richard received the letter or if he responded. The box remained in the vault, untouched. In 2013, a bank employee noted in the file that the box should be opened and inventoried, but the task was not completed. The file was misfiled. The box was forgotten. In 2018, Webster Bank underwent a merger with another financial institution, Sterling National Bank. As part of the merger, all safe deposit boxers across both banks were audited. The audit was conducted by a third-party firm hired to ensure compliance with state regulations. Dorothy's box was opened in November 2018, 11 years after her death. Inside was the will, along with several other documents, birth certificates for Dorothy's children, the original deed to the house, a copy of Robert Crane's death certificate, a handwritten letter addressed to Margaret, and a photograph. The photograph showed Dorothy and a young girl, perhaps 4 or 5 years old. The girl was Margaret. The photo had been taken sometime in the late 1960s. Dorothy was smiling. The bank contacted the Connecticut probate court in December 2018. The court determined that the will had never been submitted during the original probate process in 2007. According to Connecticut law, when a will is discovered after an estate has been closed, the court has the authority to reopen the estate and distribute assets according to the will. The court appointed a new administrator to handle the reopened estate. The administrator retained Stephen Pemberton to locate the beneficiaries and distribute the assets according to Dorothy's will. Pemberton began by searching public records for Margaret Holloway. He found her address in Providence. He sent a letter in April 2019. But there was a problem. The estate no longer existed. The house had been sold 11 years earlier. The money from the sale had been spent. The savings account had been closed. The life insurance payout had been deposited into Richard's personal account in December 2007. The funds were gone. Pemberton explained to Margaret that she had a legal claim to her share of the estate. She could file a lawsuit against Richard for the full amount she was owed, plus interest. Connecticut law allows for interest to accrue on wrongfully withheld inheritances at the statutory rate, which is 10% per year. By Pemberton's calculation, Margaret was owed approximately $228,500, plus 12 years of interest. That brought the total to roughly $501,000. But that amount was only theoretical. If Richard no longer had the money, if he had spent it or lost it, there was no guarantee Margaret would recover anything. Margaret asked if Richard still had the money. Pemberton said he did not know. He said the only way to find out would be to initiate legal proceedings and request financial disclosure. Margaret asked how long that would take. Pemberton said if Richard cooperated, it could be resolved in a few months. If it did not, it could take years. Margaret asked what it would cost. Pemberton said she would need to retain her own attorney. Probate litigation in Connecticut typically costs between $20,000 and $50,000, depending on the complexity of the case. Margaret thanked him and left. Margaret had not spoken to her uncle in over a decade. They had never been close. As a child, she had seen him at family gatherings, but he had always been quiet, somewhat withdrawn. He did not play with her. He did not ask her about school. He was simply present. After her mother died in 2003, the already thin connection between Margaret and Richard had faded almost entirely. She had seen him at Dorothy's funeral in 2007, exchanged a few words, and then nothing. She did not have his phone number. She did not know his current address. She knew he lived somewhere in Hartford, but that was all. She did not know if he was employed, or retired, or ill. She did not know if he had friends, or hobbies, or a life she knew nothing about. She asked Pemberton if he could provide Richard's contact information. Pemberton gave her an address in Hartford that he had found through public records. It was an apartment building on a street Margaret did not recognize. Margaret decided to write a letter. She kept it short. She did not want to sound accusatory. She explained that she had been contacted by an attorney regarding Dorothy's estate. She said she had learned about the will. She said she was confused about what had happened, and she wanted to understand. She asked Richard to call her. She included her phone number and her email address. She mailed the letter in early May 2019. She did not receive a response. 2 weeks later, Margaret drove to Hartford. She did not tell anyone she was going. She took a personal day from work. She left her house at 7 in the morning and arrived at Richard's address by 9. The building was a 3-story brick structure on a quiet side street. There were no names on the mailboxes. In the lobby, Margaret did not know which apartment was Richard's. She stood outside for 10 minutes, trying to decide what to do. Eventually, she went back to her car. She sat there for another 20 minutes, watching the building. No one came in or out. She drove home. In June 2019, Margaret retained her own attorney, a probate litigator named Laura Fenstermacher had been recommended by a colleague at Margaret's workplace who had gone through a similar estate dispute years earlier. Fenstermacher's office was in downtown Providence. The consultation lasted an hour. Margaret brought copies of all the documents Pemberton had given her. She explained the situation. She said she did not know what to do. Fenstermacher reviewed the case and confirmed that Margaret had strong grounds to file a claim against Richard for breach of fiduciary duty and unjust enrichment. She explained that under Connecticut law, an executor who fails to disclose a will can be held personally liable for the full value of the wrongfully distributed estate. Fenstermacher said the case was straightforward legally, but that the challenge would be enforcement. If Richard no longer had the money, collecting the judgment would be difficult. Margaret asked what the chances were that Richard still had the funds. Fenstermacher said it was impossible to know without financial disclosure. She said that in her experience, estates that go unclaimed for more than a decade are often spent. People buy houses. They pay off debts. They travel. They live their lives. But she also said that some people save. Some people invest. Some people hold on to money for years without touching it. There was no way to know which category Richard fell into. Margaret asked what Fenstermacher would recommend. Fenstermacher said she would recommend filing the lawsuit. She said that even if Richard did not have the money now, he might acquire assets in the future. A judgment would remain enforceable for 20 years. If Richard ever inherited money, or sold property, or came into any significant funds, Margaret would be able to claim them. Margaret asked how much it would cost. Fenstermacher said her retainer was $15,000. If the case went to trial, the total cost could reach $40,000 or more. If Richard did not respond and they won by default judgment, the cost would be closer to $20,000. Margaret said she needed time to think. Margaret spoke with her children about the situation. Her son, David, was 28. Her daughter, Emily, was 26. Both of them were aware that their great-grandmother had died years earlier, but neither had known her well. David asked why Margaret was considering pursuing the case. He said that if Richard had spent the money, there was nothing to recover. He said it seemed like a waste of time and money. Emily disagreed. She said it was not about the money. She said it was about the principle. Someone had stolen from their mother, and that should not go unanswered. Margaret did not say much during the conversation. Later, she told a friend that she felt stuck between two impulses. Part of her wanted to let it go. Part of her wanted to fight. She decided to fight. Laura Fenstermacher filed the complaint in Connecticut Superior Court in July 2019. The complaint was 23 pages long. It detailed the history of Dorothy's estate, the discovery of the will, and Richard's role as executor. It alleged that Richard had knowingly concealed the existence of Dorothy's will, filed a false affidavit with the probate court, and wrongfully claimed the entire estate. It sought $228,500 in damages, the amount Margaret was owed under the will. It also sought interest, dating back to 2007, calculated at Connecticut's statutory rate of 10% per year, that brought the total to approximately $501,000. It also sought reimbursement of legal fees and court costs. Richard was served with a complaint in August 2019. According to Connecticut civil procedure, he had 30 days to file a response. He did not file a response. After 30 days, Fenstermacher filed a motion for default judgment. In civil litigation, if a defendant does not respond to a complaint within the required time frame, the plaintiff can ask the court to rule in their favor automatically. The court scheduled a hearing for October 2019. Richard did not appear. The judge reviewed the case. He examined the will. He examined the probate records from 2007. He reviewed the affidavit Richard had filed claiming Dorothy had died in death. The judge ruled in Margaret's favor. The court awarded Margaret $228,500, the amount she was owed under the will. The court also awarded interest dating back to November 2007, the month Dorothy died, with 12 years of compound interest at 10% per year. The total came to $501,420. The court also ordered Richard to pay Margaret's legal fees, which at that point totaled $18,000. Margaret had won, but winning a judgment is not the same as collecting it. In order to collect the judgment, Margaret needed to locate Richard's assets. Fenstermacher began the process of asset discovery. She filed a request for Richard's bank records, tax returns, property holdings, and investment accounts. Under Connecticut law, a judgment creditor has the right to demand financial disclosure from a debtor. Richard did not comply. Fenstermacher filed a motion to compel. The court ordered Richard to produce the documents within 30 days. He still did not comply. In January 2020, Fenstermacher filed a motion for contempt of court. Failure to comply with a court order is punishable by fines or, in extreme cases, imprisonment. The court scheduled a hearing for February 2020. Richard was ordered to appear in person to explain his failure to comply. He did not appear. The judge issued a bench warrant for Richard's arrest for failure to appear at a court-ordered hearing. In March 2020, Fenstermacher hired a private investigator named Thomas Ritchie to locate Richard. Ritchie was a former police detective who specialized in skip tracing, the process of finding people who do not want to be found. Ritchie began by searching public databases. He found an address for Richard in West Hartford, the same address Pemberton had located the year before. He drove to the address and confirmed that Richard was living there. It was a small rental apartment in a complex on the west side of town. The building was aging, but well-maintained. There were about 20 units total. Ritchie knocked on Richard's door on a Tuesday afternoon. No one answered. He left a business card with a note asking Richard to call him. Richard did not call. Ritchie returned 2 days later. This time, Richard answered. Ritchie later described the encounter in a written report. He said that Richard appeared to be in his early 70s. He was thin, with gray hair and a tired expression. He was polite but guarded. When Ritchie explained that he was there regarding the court case, Richard said he was aware of the situation. Ritchie asked if Richard intended to comply with a court order. Richard said he did not have the money. Ritchie asked if he had any assets. Ritchie said no. Ritchie served him with a court order in person. Richard closed the door. In April 2020, Richard finally filed a response with the court. It was a brief motion, 3 pages long, handwritten on lined paper. Richard stated that he did not have the funds to pay the judgment. He claimed that the money from Dorothy's estate had been spent on medical expenses and living costs over the years. He said that he had undergone heart surgery in 2010, which had cost over $80,000, even with insurance. He said that he had been laid off from his job in 2011 and had struggled to find steady work afterward. He said that he had depleted his savings, trying to stay afloat. He provided bank statements showing that his current checking account balance was $2,847. He provided a letter from his landlord confirming that he paid $950 per month in rent. He provided tax returns showing that his only income in 2019 was $14,000 from Social Security. He had no other assets, no property, no savings, no investments, no retirement accounts. He said he could not pay what he did not have. Fenstermacher requested a debtor's examination, a legal proceeding where a debtor is questioned under oath about their finances. The examination allows a creditor to verify whether a debtor is truly insolvent or if they are hiding assets. The examination was scheduled for June 2020. It was postponed due to the COVID-19 pandemic. Courts across Connecticut were operating at limited capacity. Non-emergency hearings were delayed. The examination was rescheduled for October 2020. Richard did not attend. Another warrant was issued for his arrest. Margaret spent most of 2020 waiting. She would call Fenstermacher every few weeks for updates. Fenstermacher would explain that the process was slow, that Richard was evading the court, that enforcement was difficult when a debtor had no visible assets. Margaret asked if there was any chance she would actually receive the money. Fenstermacher said it was possible, but unlikely. If Richard truly had no assets, there was no mechanism to force payment. A judgment is only as valuable as the debtor's ability to pay. If Richard was insolvent, the judgment would remain on paper, uncollected, indefinitely. Margaret could place a lien on any future assets Richard acquired. If he ever owned property, or inherited money, or came into any significant funds, the lien would allow Margaret to claim those assets. But unless that happened, there was nothing more to be done. Margaret asked how long a judgment lien lasts in Connecticut. Fenstermacher said 20 years. Margaret asked what happened after 20 years. Fenstermacher said the judgment would expire. It could be renewed, but only if Margaret was still actively pursuing collection. Margaret asked if that ever happened, if people actually collected on judgments. After 20 years, Fenstermacher said it was rare, but not unheard of. In early 2021, Margaret received another letter from Stephen Pemberton, the attorney who had first contacted her about the will. Pemberton explained that while reviewing the documents found in Dorothy's safe deposit box, he had come across something that had not been included in the initial materials provided to Margaret. It was a handwritten letter. The letter was dated March 10th, 2005, 2 days before Dorothy signed her will. It was addressed to Margaret. Pemberton mailed her a copy. The letter was written on unlined stationery in blue ink. Dorothy's handwriting was shaky but legible. The paper had yellowed slightly over the years. It began. Dear Margaret, Dorothy wrote that she had been thinking about her estate and wanted to explain her decisions. She said that she loved both of her children, but that she had always felt a distance from Elizabeth, and by extension, from Margaret. She did not blame anyone for that distance. She said it was simply the way things had developed. She wrote that Richard had been devoted to her, and that she was grateful for his care. She said that without him, her final years would have been much harder, but she also wrote that she did not want to create an imbalance. She said that Margaret deserved to inherit as well, because she was family, and because Elizabeth would have wanted her to be taken care of. She wrote that she hoped the will would be clear, and that there would be no conflict. She said she had placed the will in the safe deposit box, so it would be secure. She said she had told Richard where the will was kept. She signed the letter, with love, Grandma Dorothy. Margaret read the letter in her kitchen on a Sunday morning. She had not expected it. Dorothy had never been an affectionate person. The letter was the most personal communication Margaret had ever received from her. The phrase "with love" felt foreign, almost unreal, but it was the final sentence that stayed with her. I told Richard where the will was kept. Margaret read it again. Dorothy had told Richard about the safe deposit box. That meant Richard had known the will existed. Margaret called Fenstermacher and read her the letter over the phone. Fenstermacher said it was significant. It suggested that Richard had been aware of the will and had chosen not to disclose it. That would elevate the case from a potential mistake to intentional fraud. But Fenstermacher also said it did not change the practical situation. Richard still claimed he had no money. A stronger legal case would not create assets where none existed. Margaret asked if the letter could be used to pursue criminal charges. Fenstermacher said it was possible, but unlikely. Fraud cases are difficult to prosecute, especially when they involve family members and estate matters. District attorneys are reluctant to pursue them unless there is clear evidence of intent and significant harm. Margaret asked what she should do with the letter. Fenstermacher said to keep it. She said it might be useful later, if the case ever went to trial. Margaret folded the letter and put it in a drawer in her bedroom. She has not read it again. Margaret's children asked her why she was continuing to pursue the case. They were aware of how much time and money she had spent. They had watched her stress over court dates and legal filings. They had seen her frustrated, angry, exhausted. David asked if it was worth it. Margaret did not answer right away. She said later that it was not really about the money anymore. It was about the fact that someone had made a decision to exclude her. Someone had looked at a legal document, a clear instruction from Dorothy, and had chosen to ignore it. She said it felt like being erased, not just from the inheritance, but from the family, from the record. She said she wanted there to be some acknowledgement, some admission that what had happened was wrong, but there was no acknowledgement. Richard never apologized. He never explained. He never even spoke to her. In April 2021, Richard's landlord filed an eviction notice in Hartford Housing Court. According to public records, Richard had not paid rent in 4 months. He owed $3,800. The eviction was finalized in June 2021. Richard's forwarding address was listed as a motel in Mere, Connecticut, a town about 20 minutes south of Hartford. Fenstermacher attempted to contact him there. She called the motel and asked if Richard Crane was a guest. The manager confirmed that he had been, but that he had checked out after 2 weeks. No one knew where he went. Margaret stopped pursuing the case actively in late 2021. She had spent over $30,000 in legal fees. The judgment was worth $501,000. But she had not seen a dollar of it. Every new motion, every new hearing, costs more money and produced no results. Fenstermacher told her that unless Richard resurfaced with assets, there was no point in continuing. The judgment was on file. The lien was in place. If Richard ever owned anything of value, Margaret would be notified. But for now, there was nothing to collect. Margaret asked Fenstermacher what happened in cases like this. Fenstermacher said that many judgments go uncollected. People disappear. People become insolvent. People die. The legal system can declare someone a winner, but it cannot create money where none exists. Margaret thanked her and ended the retainer. In 2022, Margaret tried to locate Richard on her own. She searched public records online. She looked for his name in Connecticut databases, voter registrations, court filings, anything that might show where he was. She found nothing recent. The last verifiable record was the eviction in 2021. She considered hiring another investigator, but decided against it. She had already spent too much. The judgment was worth over $500,000, but chasing it felt like throwing good money after bad. She let it go. Not entirely, not emotionally, but practically. She stopped checking for updates. She stopped calling attorneys. She stopped thinking about it every day. Margaret still thinks about the safe deposit box. She thinks about the fact that if Webster Bank had followed standard procedure in 2012, the box would have been opened 6 years earlier. The will would have been found. The estate would have been reopened while Richard still had access to the funds, or at least some of them. She thinks about the fact that if Dorothy had kept the will at home, or given it to an attorney, or told someone else where it was, things would have been different. She thinks about the letter that said Dorothy had told Richard where the will was kept. She wonders what Richard thought when he received the probate paperwork after Dorothy died. She wonders if he went to the bank and opened the safe deposit box. She wonders if he read the will, saw Margaret's name, and made a decision, or if he never went at all. She does not know. There's a legal concept called constructive fraud. It refers to situations where someone in a position of trust violates that trust, even if there was no intent to deceive. When Richard filed the affidavit stating that Dorothy had died intestate, he may have believed it was true. It is possible he did not know about the will, or did not remember that Dorothy had mentioned a safe deposit box, but it is also possible that he did. Margaret does not know which version is true. She has never spoken to Richard since the lawsuit began. He never called her. He never responded to her letters. He never appeared in court. He never defended himself. She does not know if he avoided her out of guilt, or anger, or simply indifference. She does not know if he spent the money on medical bills, as a clay med, or on something else. She does not know where he is now. She does not know if he is still alive. In Connecticut, there is no criminal penalty for failing to disclose a will if the failure cannot be proven to be intentional. Executors have a fiduciary duty to conduct a thorough search for testamentary documents, but breaching that duty is usually a civil matter, not a criminal one. Richard was never charged with a crime. He was found liable in civil court, but that liability has never been enforced. The judgment exists. The lien exists, but the money does not. Margaret's children ask her occasionally if she has heard anything. She has not. The judgment is still on file. The lien is still in place. If Richard ever buys property, or opens a bank account with a significant balance, or inherits money from someone else, Margaret will be notified. If Richard dies and leaves an estate, Margaret's claim will be considered among his debts. But estates are only worth pursuing if there is something to claim. Until then, there is nothing to do but wait. Margaret keeps the photograph that was found in the safe deposit box. It sits on a shelf in a living room, in a simple wooden frame. The photograph of Dorothy and 4-year-old Margaret smiling in someone's backyard. She looks at it sometimes. She wonders what Dorothy would think if she knew what had happened. If she knew that the will she carefully prepared, the letter she carefully wrote, had been ignored for over a decade. She wonders if Dorothy would be angry, or sad, or just resigned. She wonders if Dorothy would tell her to keep fighting, or to let it go. She does not know. Dorothy Crane died on November 14, 2007. Her will was discovered on November 9, 2018. Margaret Holloway was notified on April 3, 2019. She filed a lawsuit on July 12, 2019. She won a judgment on October 17, 2019. As of 2024, she has not received any payment. 17 years have passed since Dorothy's death. The estate was reopened 12 years too late. The money was already gone. If you're interested in documented inheritance cases and unresolved family disputes, consider subscribing.